Hello everyone, my name is Mitch Handley from Inventory Hive and I'm joined today by Martin Wilks, who's an adjudicator at the TDS. Obviously, before we get started, I just want to thank everyone who's registered for today's webinar. Obviously, expecting it to be a really popular one today with close to 100 people already registered. If you do have any questions, because obviously it's a National Adjudicator live session, there is a little chat box on the right hand side. So on the right hand side, if you just hit the red arrow, that should open up the panel. On some people's devices, it might be on the left hand side, actually, depends on what device you're using. And then you just type in your questions here for myself and Martin, and we'll work through those today for you. We've got an hour booked in. We've already received quite a number of pre-submitted questions. So what we plan on doing today is running through some of those to start with, and then if any more live questions do come in, we'll answer those questions and then jump back to the pre-submitted ones as well. So we'll do a bit of to and fro in between the questions today. But if you do pop any questions in the questions box, what I will just recommend, or what would really help me and Martin, is just to be type out the questions as simply as possible. We've had questions before where they've been abbreviated or used like short letters, and we can't really understand them, especially on a spur of the moment thing. So do type out your questions with as much detail and as clear as possible for us, and that would really help myself and Martin to answer your questions today. So yeah, before we get started, Martin, did you want to introduce yourself first and then wait for some questions to come in, and then we'll get started?
Yeah, thanks, Mitch. So yes, I'm an adjudicator at TDS. I have been with TDS now for almost 10 years, so I've dealt with thousands of disputes in that time. I deal with the adjudication, but I also present on the TDS Academy courses and do things like this, the webinar as well. I'm not sure who's going to have the tougher job this morning, whether it's me being put on the spot, whether it's Mitch trying to manage the questions, but hopefully we'll have a really good session.
Brilliant stuff. Thanks, Martin. And yeah, for anyone who doesn't know, I'm Mitch from Inventory Hive. We've got a great working relationship with the TDS. We at Inventory Hive provide software to letting agents, inventory clerks, landlords, student accommodation providers, so they can use our software via desktop or the Inventory Hive app to create detailed condition cleanliness reports such as check-ins, check-outs, interim inspections. You can do custom reports as well, like Legionella risk assessments, damp and mold reports, which we'll come on to later on. So you can use our software to create those reports for the properties you manage. So yeah, so let's get started and now head over to question number one. Just to warn you guys, obviously, some of the pre-submitted questions will come in were quite long, so we do apologize about that, but we'll work through them when we can. So yeah, so the first question for you guys is, why are carpets assumed to have an arbitrary lifespan of 10 years? I put exactly the same carpets into my own home 1 year before putting the same new carpets into my rental property. At the end of the 9.5 years occupation by the same tenants, their carpets were ruined by red wine and coffee stains and so on. In my home, mine still looked in excellent condition and stain free. However, nothing was awarded to me from the deposit because they were 10 years old. How's this fair when we're not talking about wear and tear, we're talking about actual damage? So obviously over to you, Martin, if that's okay.
Yeah, I mean, I had a sneak peek at this a couple of minutes before we came on today, and I think this is a really good question. It highlights lots of issues, actually. The first thing to say is that items in a rental property, they just simply don't last forever. So things will always diminish. As soon as you fit something, a carpet, for example, in a property, its value starts to diminish over time. And we have to accept that. In this case, this landlord has fitted them the exact same carpet in their own home and in a rental property. Reasonably, we have to consider the fact that in a rental property, a carpet will be subjected to a greater level of wear and tear. It's as simple as that. You know, in this case, maybe the landlord lived alone or lived with their partner only. They didn't wear their shoes indoors. They didn't have many visitors. But in a rental property, we have to make a reasonable allowance. And so maybe it was a family with children. Maybe they didn't take their shoes off when they entered the property. So we have to accept that these things are going to deteriorate perhaps faster than in your own home, or if you purchase these carpets for yourselves. A landlord will never get the new for old replacement cost, because that will put them in a better position. So what an adjudicator has to do is to work out the value of an item, because in order to claim from the deposit, a landlord will have to show that the tenant has breached the terms of the tenancy agreement and that the landlord has suffered loss. Now, in this case, obviously I haven't seen the evidence, and I'm only going on what's being told to me, but there were stains from red wine and coffee on the carpets. Well, this would be damage. You're quite right. We're not saying this is fair wear and tear. We're saying this is damage. The tenant did damage those carpets. But what's the landlord's loss? You know, we've established a breach, but has the landlord suffered loss? And the adjudicator in this case clearly considered that these carpets had diminished in value to the extent that they didn't hold any intrinsic value by the end of the tenancy. Those carpets would most likely have worn out in any event after 10 years and would have needed to be replaced. And I think that's a reasonable assessment. We have on our TDS website, on the help centre, there's a useful lifespan useful lifespan guide, which is a great starting point for these things. And, you know, carpets generally, you know, sort of 8 years for an average quality carpet, maybe up to 15 for a high quality carpet. But you've got to demonstrate the quality, the type of carpet that you've installed at the start. So remember to provide those original invoices and receipts to establish how old they were and how much they cost. That's a big help to the adjudicator. But in this case, it's not that we're saying it's just fair wear and tear. We're just saying that there was no residual value in those carpets by the time the tenancy ended.
Just to add to that, Martin, is it beneficial to you as an adjudicator? So let's say a property inspector does the check-in inventory report. If they put in the notes section on that report saying whether it's a single tenancy or a family with pets, etc. So would that be beneficial to you? Because obviously that will help you determine how much wear and tear would happen based on who's living in the property, if that makes sense. So.
Well, yeah, it does make sense. I mean, adjudicators like me, you know, we always want as much information as we can, because often we're asked to make decisions where the evidence isn't quite perfect. It's not quite all there. We like the certainty of knowing. So having this information readily available is useful. We can often get that from the tenancy agreement as well, because it will name the tenants and often it will name the permitted occupiers as well. But yeah, if it's in the notes, it's all helpful, you know, as much information as possible.
Lovely stuff. Question number 2. So I'm a landlord with an ongoing tenancy with ongoing dispute regarding the money that the tenant deducted before paying me rent. So he paid £15 only for 1 month from the £750 rent. His reason is that I received money from his discomfort from my insurance during the work that took place following a leak. We had to renovate most of the kitchen, leaving him without the use of his kitchen. The issue is that the kitchen without the use lasted a lot longer than anticipated, leaving me out of pocket as the insurance claim was settled before the completion of the work. However, the tenant got discomfort money paid for a few weeks, but not all. So he took the matter into his hands and counted further 3 weeks discomfort money that he decided to keep. So he decided to keep £730 from the rent that he should have paid to me. Now he doesn't accept that. It should be counted as rent arrears for me to claim from his deposit. I appreciate your reply if I should be able to deduct £730 before giving him his deposit back when the tenancy ends. So quite a mouthful, that one, but yeah.
Yeah, it is a long one, yeah. I was reading ahead trying to you know, get some thinking time on this one. So I think that the first thing to say is you can't just make a deduction from the deposit. You can't just take out the £735 and give the tenant back the rest. In order to be able to lawfully take money from the deposit, you need to have written agreement between the parties, an adjudication decision, or a final court order. That's what the law says. So you can't just take the money out. So if the tenant is disputing this, you're going to have to negotiate with them and come to an agreement, hopefully, in an ideal circumstance. If the tenant has already been afforded some discount for the discomfort, because clearly not being able to use the kitchen in a breach of that agreement by the landlord. So the tenant has probably got legitimate claim here. They've already been compensated for some of this discomfort. The works did run on, which is unfortunate. The claim was already settled, so you've got no recourse to recover this money from your insurance company, it seems. But that doesn't mean that the tenant hasn't still suffered. They haven't had the use of this kitchen. So it would be wise, I think, to try and reach an agreement with the tenant on this point. I will make it clear, though, that when claims come through to adjudication, the deposit is taken as security for the performance of the tenant's contractual obligations, not the landlord's. And as a consequence, that means that adjudicators can't consider any claim or counterclaim made by the tenant against that landlord. So if this case were to come before me, for example, I would look at the contractual obligations of the tenant, which would be to pay rent. And if the tenant hadn't paid rent, then I would be making the award from the deposit. So this is some knowledge that perhaps might help you in your negotiation, but that doesn't mean that the tenant might not then, even when the deposit's dealt with and you've successfully recovered this £735, the tenant may choose to pursue this in court, and you may be on the receiving end of that action and have to defend those actions and potentially compensate the landlord, the tenant at a later stage. So my advice would be to try really hard to try and reach a negotiated agreement on this.
Nice stuff. Thanks, Martin. So this is quite an interesting one, and one that I personally get asked quite a lot as well. So obviously, Inventory Hive is used by letting agents who want to do their inspections in-house and by independent inventory clerks who work on behalf of agents who outsource their reports. So it kind of links to this really. So do adjudicators take into consideration if a report was completed by an independent clerk? If you had two reports exactly the same, but one was done by a landlord/agent and the other was done by an independent clerk, does the independent clerk's report carry more weight?
Well, I mean, that's a tricky question to answer. I think that the short answer is no in these circumstances. I think that when we are talking about check-in and check-out reports, what the adjudicator is looking for is evidence of condition and cleanliness at the start and the end of the tenancy. And it can come in all shapes and sizes. Best practice is to have an independent, professionally prepared check-in and check-out report, written comprehensive report with supporting images. That would be best practice because you don't really know what's going to fall into dispute when you do the check-in, for example. So we need a kind of belt and braces approach, and having a proper structure to that is far more beneficial. If at the end of the tenancy, the landlord chooses to do their own inspection or the agent does it, you know, as long as it's done to a good standard, the adjudicator will consider it in exactly the same way. The issue is that when a landlord sometimes does their own checkout report in particular, is that it starts to lack a bit of objectivity. And that can creep into how they've done the assessment, in the language that they use, and the level of detail sometimes. You know, these are things that adjudicators will consider because we do think about all of the circumstances. So it might be that when it's done by a landlord themselves, their evidence does become slightly less reliable because of the language that they've used. The only thing I will say is that in my experience of seeing the negotiations before it gets to TDS, before it gets to me, where you can point to an independent check-in and check-out report, it's far more persuasive to a tenant because it's taken away. They don't feel that it's the landlord or the agent that are trying to get hold of their deposit. You can point to the checkout report and say, look, you know, this isn't just us saying this. An independent professional clerk has been out and they have determined that this is the issue. And it can sometimes go a long way in assisting with that negotiation process. So adjudicators do think about this in the round, but it's not going to necessarily undermine your claim if an agent or landlord does their own version.
Well, this question that's just come in, it kind of relates to this one. It says, can the landlord carry out the report himself if it is at a high standard? So you kind of touched on that at the very start. If the landlord or agent is creating that report to a high standard, you said about how evidence can be passed over to you guys in all shapes and sizes, whether it's on email or on a proper PDF report done with Inventory Hive or on the back of a cigarette packet almost. But as long as that evidence is done to a high standard and that report's done to a high standard, then I suppose from your case, Martin, you'll be able to accept that evidence.
Yeah, absolutely. I mean, I think that, yeah, you know, check-in reports aren't quite the same. Check-in reports are a little different because the tenant's moving in, and as long as they're given a copy of that check-in report, they're in a position to challenge it, to add to it, vary it. And this is what we really like to see, the opportunity of the tenant to, challenge that check-in report if necessary. When we get to the end of the tenancy and the tenant's gone, there's no opportunity there. And if a landlord produces, a Word document with no photographs and uses words like destroyed my property or they've left it filthy and things like that, it's not reliable evidence. But if a landlord could produce a really good quality independent report with supporting images, then the adjudicator will consider it just like they would anything else.
Lovely stuff. Got quite a few questions come in, but we'll come on to those after the next one. So the next one is, we created a check-in report, but we used photos in the report that was taken 2 weeks ago. Is this still acceptable? Just to point out, obviously, with Inventory Hive, we date and time stamp photographs on reports, so it helps adjudicators understand when the photo was actually taken and when it was slotted in the report. But from your perspective, Martin, I don't know if there's a leeway or a standard of how old photographs can be, really. So
yeah, I mean, whenever we're dealing with a check-in report that's been prepared in advance, and normally it's where a tenancy is due to go ahead and then for whatever reason it doesn't, but the check-in report's already been done and property managers try to reuse that check-in report for the next tenancy, which might begin a couple of weeks later, like in this example. In those circumstances, because that evidence no longer reflects the conditional cleanliness at the start of the tenancy, it shows it 2 weeks earlier or more, it's not going to be reliable on the face of it. We're going to need something a little bit more. And so what we look for there is an express agreement by the tenant that it is still an accurate reflection of the condition of the property. So as long as it's signed by the tenant or agreed expressly in an email, for example, then the adjudicator would still rely on it. In this case, if what they're saying is the check-in report was done, but it was just that the photos were older, that really wouldn't make too much of a difference on the face of it. But you never know, because when we get to the dispute and we're starting to have to look in great detail at these issues, the tenant might have taken some of their own photos when they moved in, which directly contradicted these check-in photos, and then we're in a bit of trouble. We're going to have to decide whose is most reliable, and it's probably going to be the tenants, provided they're dated. So, it is difficult. We never really know what's going to come in to dispute, but best practice would be get that check-in report done right at the start of the tenancy, and get it agreed and signed by the tenant.
Yeah, I think getting it agreed by and signed by the tenant is quite crucial, really. I quite like the fact how you said earlier is you should encourage your tenants to challenge the check-in reports. I know sometimes it's quite funny, really, that encouraging your tenants to challenge the check-in report, I feel, is really important. I know agents or inventory clerks might feel that they are criticising the report and you might take offence to it, but really it's saving you a lot of hassle in the long run. Excuse me, because it reduces that chance of a dispute at the end. Although they are challenging your report and they're actually adding more evidence into your report to reduce those chances of a dispute. So don't really take it to heart, is what I'd say. I know some agents don't like it because they feel like the tenants are being, what's the right word, inconvenient at the start of the tenancy, but they're not. They're actually adding more evidence and actually helping you at the end of the tenancy. So when you do create that checkout report, you've got everything side by side in one document then that you've clearly engaged with that tenant at check-in.
And I mean, further than that, Mitch, as well, if we get to a dispute at the end of the tenancy and all of a sudden the tenant can produce dated photos that they took at the start that they didn't tell you about, the adjudicator will probably have to consider them. As long as it's reliable evidence of condition and cleanliness at the start of the tenancy, they're going to consider them, and you might not even know about it. So encouraging your tenant to agree and sign that check-in report and to amend it even really is good practice, because nothing's going to take you by surprise at the end. Everybody's had the opportunity to agree it.
We've just had a few questions come in. So what I do, this next question kind of relates to what we've been talking about, and I'll get a sample report on the Inventory Hive website up now for you guys to see. But one of the questions was, what language is acceptable when creating a report? Is there a template as such? I know the TDS provide some. Do you provide some sort of worded templates as such, Martin?
There is guidance on our website about what makes a good check-in and check-out report. I mean, clearly we're looking for objectivity, really. So, you know, we're talking about damage with cleaning. You know, there are accepted levels of cleanliness. I mean, the industry tends to use things like domestic standard, good domestic, professional clean, you know, very poor, things like this. So we're just looking for the objective language. When things are described as filthy, or you know, things like this, it just brings in this level of subjectivity, which then just becomes a little bit less reliable.
We've got, obviously I've got an example report on the Inventory Hive website here. We provide some like off-the-shelf templates that inspectors can use when creating a report. So it already pre-populates some descriptions in based on, say, a good description, but inspectors can then tweak those if they want to. Like, for example, here, like the ceiling in the entrance and hallway was plastered and painted white covering, stain present on the cover of the stairs. So that's something that the inspector might have populated in themselves. You've got the smoke alarms where they say the ceiling mounting, test function working, note to tenant, please test periodically. So it's not overly detailed, if that makes sense, but it's all an adjudicator would need in this situation, if that makes sense. There's an example here of where the report has had tenant engagement at the start. Like, for example, the front door, the inspector originally said it was free of marks and scratches to the front side and reverse, glazing in a good clean condition. But then when the tenant moved in and challenged the report, they noticed that the letterbox was not fixed properly and the security chain is missing. And the inspector can agree with that because the tenant can then evidence that photo and add that in the report as well. Again, all date and time stamped as well, just for clarity as well. So the original photos were taken on, say, the 14th, and then the tenant added theirs in on the 15th. So it's all audit trailed nicely in the report there. So hopefully that answers your question about what language is acceptable. Had a question come in saying, do all reports need photos and a written description? So obviously from your perspective, Martin, the more the merrier, I suppose. So
Well, yeah, I mean, again, adjudicators want as much information as possible. Really, we always say written word is paramount, because if, for example, you wanted to assess the skirting in a room, you would have to provide a photograph of every single section of that skirting for the adjudicator to be able to conclude it was clean and free from damage. Whereas if you've got the written word and it just says skirting, good clean condition, that suffices. The adjudicator can go on the back of that. We expect to see photographs for things like pre-existing damage, because if an item becomes more damaged or it's exacerbated in some way at the end of the tenancy, you're going to be inviting the adjudicator to assess how much it's deteriorated between check-in and check-out. And without having that starting point, the photograph from the start of the tenancy, the simple comment that there was pre-existing marks or damage isn't going to be sufficient. And you know, you have to kind of keep it in your mind as property managers and landlords that the money belongs to the tenant, and any claim that you want to make against their deposit must be proven on the balance of probabilities. And if there is uncertainty or lack of clarity, it goes against the landlord. It's going to go in favour of the tenant because it's their money. That's what the law says we have to do. So to eliminate that level of uncertainty, you need to provide very clear evidence from the start and end of the tenancy. So written word and supporting images would be the way to go.
Someone's asked, would it be good to get some basic templates for free? With Inventory Hive, we provide you with some free templates that you can use off the shelf as such in your reports. I think Martin said earlier that there are some guidance on the TDS website as well about what to put in your inspection reports. But I'll come on to it later on. But Inventory Hive and TDS do some like TDS Academy training courses. So they're we'll come on to in more detail, but basically they just help you bring you up to scratch on what to include in your reports, but we'll come on to those later on. Just looking through some of the questions now, 1 second. How soon should you do an inventory for a property? So I suppose an example being, if the tenant's moving in 2 weeks' time, would you do the inspection, say, 2 weeks before, or is it best to do it the day before, or what would you advise? Obviously, I'd assume it would be the closer to the move-in day, the better.
Yeah, absolutely. I mean, check in as close to the start of the tenancy as possible, and check out the next day or as soon as the tenancy ends is ideal. We're looking to compare, in the vast majority of cases, evidence of condition and cleanliness at the start and the end of the tenancy. Any delay between the check-in report and start of the tenancy or the end of the tenancy and checkout will undermine the reliability of that evidence, to the extent that eventually that evidence will just be worthless. It will have no evidential weight whatsoever, because anything could have happened in the intervening period. Sometimes we get agents who forget to do a check-in report, so they rely on the check-out report for the previous tenancy. Well, if that was 2 weeks before, and bearing in mind that period between tenancies is normally when work is carried out, that evidence is just not going to be reliable about what that property was like right at the start of the tenancy. So as soon as possible to start and end of the tenancy is what we're looking for.
Another question that's come in saying, when is an expert not an expert? We had a professional cooker cleaner tell us that, sorry, I'm just trying to read it here, 1 second. I'll start again. When is an expert not an expert? We had a professional cooker cleaner tell us that the tenants had damaged the cooker beyond repair due to using it incorrectly, using incorrect cleaning products. We had to replace the cooker, and this was not accepted on the report supplied by the professional cleaner. So not a very clear question. I'm trying to...
No. I think they're going with that. I mean, it is difficult. The first thing to say is that we at TDS, as adjudicators, we can only go on the documents that are provided to us, and therefore we can't accept witness evidence. So tenants and sometimes landlords like to get a neighbour to comment on what's happened or whatever, but we just can't accept it. And the reason is that we can't, it's not like a courtroom, we can't observe that witness give the evidence or test its reliability through cross-examination. So we just can't accept it. We do, however, accept specialist reports from a suitably qualified expert. The difficulty is that sometimes those lines, they become a little bit blurred. I had one recently where it was a claim for an immersion heater thermostat, and the so-called professional report basically said that the tenant had turned off the gas in order to save on their bills, and that meant that the immersion heater was working too hard, and that's what's caused this damage. In those circumstances, it wasn't really a professional report. This was more of a witness statement, because the contractor couldn't possibly have known that the tenant was doing this to save money. It's not about their professional qualifications. They were making an observation, so it wasn't reliable. Now, it's difficult for me to comment on the specifics of the case without seeing all of the evidence, but the adjudicator in that case perhaps felt that the oven cleaner wasn't in a position to say that oven was damaged beyond use. And that may well be a reasonable conclusion to make. Cleaning contractors are experts at cleaning, but they're not necessarily experts about whether an appliance needs to be replaced or not. So the adjudicator probably just wasn't persuaded by that evidence. If they've damaged the oven, if they damaged it, then that should be visible from the photographs and from the check-in and the check-out report. You shouldn't have needed a professional report in those circumstances. But that's the only thing I can suggest, really, is that the adjudicator just didn't feel it was quite persuasive enough that the oven cleaner wasn't offering a professional expert opinion. They were just offering an observation.
Lovely stuff. Do the photographs need to be close up for every room and detailed? So we've got a similar question. Well, not a similar question. We had a question come in to us as well, pre-submitted, about using 360 photos as well. So it could kind of tie into this, really. So so on to you, Martin, really. So I know in Inventory you can embed 360 photos in your reports as well, which helps adjudicators, I suppose, with getting a good context to the room, showing all the light fittings working, smoke alarms. And then I suppose it's a case of, if there are any damages and defects, take some photographs of, say, the damages and defects and common dispute items, but nice clear photographs. You don't want any blurry ones or shaken ones, I suppose.
No, exactly. I mean, we're trying to just line up those two bits of evidence from the start and the end of the tenancy and be able to make a comparison between the two. Now, at the start of the tenancy, there's probably no real need, and you probably don't feel it necessary to take close-up photographs of every aspect of the property. But what we probably are going to be looking for is some sort of context to see how the room is laid out and all the rest of it. And if there is any pre-existing damage, as Mitch says, nice clear images of those, because inevitably they're the ones that fall into disputes, and adjudicators have got to make that direct comparison. At the end of the tenancy, again, if you're trying to highlight specific damage, it's a really good idea to have that kind of wide-angle shot to provide the context, and then have the close-up and try and scale it as well. Include things in the image that are going to provide some scale. A tape measure would be ideal. If I was an inventory clerk, I'd have one of those little tape measures on my key ring or something, to offer up to give us some scale and context, because adjudicators are always going to concern themselves with how severe the damage is and whether it's in a prominent area of the room, because damage right in the center of a carpet is probably going to attract a greater level of compensation, or perhaps justify its replacement, as opposed to the same damage in the corner of the room where it's going to be covered by a chest of drawers or whatever. So give us as much information as you can, absolutely.
Another question that's come in, is there a time frame a tenant should return the inventory? So it kind of ties into the point of where we mentioned about engaging with your tenants at check-in. What I'm just going to tell you here will answer another question the same person's asked, really. So with Inventory Hive, you can send your reports digitally to your tenants via email, so they can provide feedback on the report. So when the property inspector's done the report, they click the submit button, that gets emailed to the tenant. So the tenant can then move in, get settled in the property, and they have a set time frame to have a look around the property, check everything works, like the oven, the shower, there's hot water, and any damages and defects really that were missed from the report, and they can provide that digitally. We typically advise 7 days, but you can alter that on Inventory Hive to whatever you like. So I suppose the question for you, Martin, is there a set standard in the industry on how long you should give your tenant to feedback on the original inventory report and when they should return it?
Well, there's no set standard. It's whatever's reasonable, and 7 days, 10 days, these are reasonable periods of time, so there's no issue with that at all. One of the good things that you've mentioned there, Mitch, is that this email is sent containing the report, because tenants do sometimes say to adjudicators, I wasn't given a check-in report, or I didn't see the check-in report. And if they've not been given the opportunity to comment, it does become a little bit difficult for the adjudicator, because how will a tenant know to say that a property was only clean to an average standard, not a good standard, if they didn't know that that's what was recorded in the check-in report? So being able to evidence that you've sent that report is good as well, particularly if the tenant starts to run that argument with you in the negotiation. So do provide that evidence as well. The only thing I will say is that, again, if the tenant does, at the end of the tenancy, spring on you some evidence that they captured for themselves at the start of the tenancy that they didn't tell you about, the adjudicator will probably still consider that. Even if they haven't commented within the 7 or 10 days, but if they've signed that document or agreed it expressly within the time period, then that's going to be very persuasive. The adjudicator might not consider their additional evidence then that they've sprung on them. So I do always encourage you to get those reports signed or agreed right at the outset.
I suppose with the signatures as well is we send reminder text messages and emails to the tenant as well, just saying, don't forget to sign off your inventory, don't forget to feedback on it. So there are plenty of prompts available within Inventory Hive, and it's all got a date and time stamp of when they sign for it as well. So yeah, I know I know with quite a lot of universities we work with, they set the time frame to a lot longer because students move in through a different period of time, if that makes sense. Whereas I think 7 days is probably fair because they might be eating out for the first 3 days, for example. So they might not know until the oven's broke until day 4, or there's no hot water. Well, hopefully they have a shower within 4 days, but yeah, but you get what I mean. I think putting pressure under the tenant to sign the inventory straight away when they've only just got moved in, there's a removal van out with all the furniture outside, etc. Trying to get moved in, it's a high emotions for the tenant. So I wouldn't put the pressure on the tenant to sign the inventory report straight away, because they'll just sign it off, give it back, and then there'll be a problem a few days later. Just let the tenant get settled in, let the emotions run out of when they're just moving into the new property, and they'll be able to provide nice feedback on your reports. Right, let's have a look at some more questions. A landlord is making a claim for damage to his walls for deep scuff marks, and the tenant painted one room for a baby with big grey clouds. Lovely, nice. The landlord is claiming £360 for the hallmarks and to paint the bedroom back to white. The tenant is claiming she will not accept the deduction because the landlord is already painting the property. Can the tenant win this argument?
Well, I'm not quite sure what she means by the landlord's already painting the apartment. I mean, if we're talking about lifespan again, just like with our carpets, you know, decor can only reasonably be expected to last 3 to 5 years. So if this tenancy lasted around that length of time, or if the decor wasn't new at the outset, then you know, maybe the landlord would have had to repaint in any event. So they might not get a contribution towards painting the hall. If the tenant's painted big grey clouds on the bedroom walls, though, then this is probably going to incur greater costs because they might need to have an extra coat of paint, for example. So they're probably going to be entitled to an award towards that, but it won't be the full cost of redecoration. It will only be a contribution towards it. Things like damage, you know, if there are deep gouges or, you know, scuff marks that have damaged the surface of the wall, then of course this is damage, and we can make an award from the tenant's deposit to repair those walls.
Is it a case of, does the tenant need to ask the landlord for permission to paint those walls originally, the bedroom walls?
Well, the tenancy agreement will often say that you're not to make any alterations to the property unless you have the landlord's consent. We always encourage landlords and agents to keep that audit trail, you know, to keep it all on email. Don't have the conversation over the telephone, because often they will say, you can paint big grey clouds on the wall, but you're going to have to paint the walls back to white at the end of the tenancy. And that's a good way to get the tenant to do that, to fulfill that obligation, repaint the walls white, and then the landlord doesn't have to go to any trouble or expense in remedying that breach, and everybody can move on. If the tenant doesn't do what they agreed to, then of course we can make a contribution towards redecoration, but it wouldn't be the full cost, even if the tenant agreed to repaint them. It would only be to reflect the landlord's loss. So we take into account how old the walls were and all the rest of it, and just award a contribution towards painting them back to white.
I've had quite a good question come in. It kind of kills 2 birds with 1 stone, because we had another similar question come in as well. So we are now entering winter time, and a lot of properties we go to, the lighting isn't great. So when taking pictures, it's very hard to show how it really looks, and something might get missed. Do we need to make sure we have worded descriptions more detailed if highlighting something that is hard to see? And that goes with the other question is, are photo cameras quality accepted? Is a phone camera quality accepted? So I suppose it's down to the quality of the images.
It is. I mean, it's really difficult to kind of talk about these things. You know, nothing is rarely perfect, but we do want to have nice, clear evidence, a good, objective written description, and nice, clear photographs. If you can't get those clear photographs, if I was the property manager, I'd be thinking that I need to perhaps spend a bit more time on the written description to compensate for that. But yeah, absolutely. I mean, clear images, use flashes, you know, whatever. Try and get the best quality that you can. We do accept phone images. You know, there's nothing to suggest the quality is any worse than, you know, using a tablet or a digital camera. You know, in fact, the vast majority photos I see these days are done on a mobile phone. My only word of caution is don't assume that we can always date a digital image, because if it's not shown on the image, which they're not on a mobile phone normally, you might need to provide that metadata as well, or at least upload it in a format where we can check the metadata, because we do get a lot of photographs submitted and we just can't date them. It'll be the date they were uploaded, or it will be today's date, because that information isn't included. So date and time-stamped image is best quality, best available evidence.
You just touched upon there about whether digital photos or phone cameras or even a CD-ROM photo, for example. Obviously, as long as the images are clear, they should all be accepted. We had a question on, should signatures be written or is digital okay? I suppose digital is absolutely fine, I suppose, because there's important documents. I think when I was even purchasing my house, I had to sign a lot of stuff digitally. So written or digital signatures should be okay. I assume that's the same from a TDS standpoint as well, Martin.
Oh yeah, absolutely. I mean, if we tend to accept evidence on face value unless there's any reason not to, and having a digital signature on a document, a check-in or check-out report is perfectly acceptable. We're not going to get into any trouble over that, I don't think.
Right, let's head on to the next one. If a tenancy began on the 1st of July and then tenants reported bed bugs, obviously bed bugs are quite a talking point in France at the moment. So onto bed bugs. So and then the tenant reported bed bugs 3 months later in October, then would the tenants be deemed responsible for payment of treatment? And would the landlord be able to deduct this from the cost from their deposit if they did not pay? The argument from the tenant would be that they did not notice the bed bugs because the larva eggs were still incubating in the fabric of the property. However, take a student property where the tenants come back to the property and only move into the house in late September, whereas the contents have already been in the property for 3 months. The returning tenant is probably the one who spent the summer holidaying abroad and has picked up the bed bugs, which are now in their suitcase and clothes. Who is responsible for what can be a very expensive eradication, especially if new mattresses are required?
Well, I mean,
long one, that one. So
yeah, it's really difficult, and I in a lot of circumstances, a landlord will be in a very difficult position because things will happen in their rental property which are a nuisance and an inconvenience. But we've got to think about what we can prove and what we can show. And as I mentioned earlier, we think back to basics. Has the tenant breached the terms of the tenancy, and has the landlord suffered loss as a result? Now, a tenant can't be deemed to have breached the terms of the tenancy agreement if they haven't caused this bed bug infestation. It just happened to be in the property. And the thing about bed bugs is that they migrate easily. They jump on clothing, suitcases, they even walk between rooms. And so if you've got a house of multiple occupancy or a tenant student accommodation or whatever, what's to say these bed bugs haven't trotted on down the hall from a different room? So you're going to need to establish that it was this tenant who most likely caused that breach, on the balance of probabilities. I think that the best thing to do would be to consult an expert, a pest controller, who can come in and give you some sort of advice and assessment, and perhaps even provide a report, which you could then use as evidence to establish the tenant's breach. But if you don't provide any of that, and you're simply saying that this student in a house of multiple students arrived, and we're only looking at this one tenancy and this one room in this student home, are we going to be able to say that this tenant caused the bed bug infestation? It's probably not without something extra. So think about whether you can establish the breach before you get too embroiled in whether you're going to recover this money from the tenant or not. I know it's not perfect, but it is the landlord's obligation to prove their claim. We can't just assume that it's the tenant's fault.
Another question that's come in, what is the difference between a fair remark and a good remark? Would you say it is fair condition if it had marks and good if no marks?
Well, yeah, I mean, good condition means that it is just that, it's free from marks and it's in good visible condition, working order or whatever. If it's fair condition, then it's probably going to be a little bit rough around the edges, maybe some surface scratches, maybe a bit of wear visible, top layer of paint rubbed off, that kind of thing. So there is a definite distinction between fair and good, you know, and everybody who uses it, kind of, you get a feel for it. So this is why sometimes perhaps, you know, having that professional inventory clerk is a good idea, because they know how to utilize this language most effectively. Because an adjudicator will also look at the photographs. So your photographs should be supporting these visible assessments as well.
A pre-submitted question that came in is, if a check-in report is not signed, will an adjudicator still accept it for evidence? And it goes along with the question of, are digital signatures or electronic signatures, how do they stand from a legal standpoint? From the legal standpoint side of things, we've got documentation at Inventory Hive to show that signatures captured are EU legally binding. So hopefully that covers it from a legal standpoint. If it's date and time stamped and we've got an IP address as well from electronic signature, then there's evidence there that that person signed that document. So from that standpoint, hopefully that answers your question. But with regards to no signatures at all, will an adjudicator still accept the evidence?
Yeah, absolutely. I mean, if it's the best available evidence to an adjudicator who's being asked to make a determination on a case, then yes, absolutely, we'll still consider it. The only risk is that the tenant might turn around and say, well, actually, I didn't get it. And the adjudicator might have to give some thought to that. It might affect the outcome. Or they might say, I didn't sign it because this is the state that I saw it in. And they suddenly produce their own evidence, which the adjudicator will have to consider. So for certainty, get the signature. But if a lack of signature doesn't mean that the adjudicator is going to dismiss that evidence and not consider it, we'll consider it in the same way. It's just that it is open to challenge.
Lovely stuff. How do we get tenants to ensure they keep the gas cookers clean and grease free? So I suppose from an adjudication perspective or deposit deduction, I suppose at the end result is they must return the property in a reasonable condition from at checkout to when they moved from check-in. So I've heard good examples of where a tenant's moved in, but during the tenancy, it's absolutely dirty. There's muck everywhere. There's rubbish everywhere during the tenancy. But when they move out and they return the property to the similar condition to when they moved in, then I suppose no deductions can take place because they've returned the property how as expected. But I suppose during the tenancy, how do they ensure they keep the gas cookers clean and grease free? I suppose it's up to the tenant to manage that during the tenancy. They can live in the property however they like, I suppose. It's just as long as there's no risk to their health is a good thing, obviously, with damp and mold, etc. But obviously, I suppose it's easier at the end of the tenancy if you're keeping those gas cookers clean and grease free during the tenancy, because it will just make it easier for you at the end of the tenancy as well.
Yeah, I agree with you. I mean, we as adjudicators, we are only concerned when tenants has fulfilled their obligation, which is to return the property as clean as it was at the start of the tenancy. So midterm inspections are limited in value. We tend to look at those to establish things like whether the tenant has kept a pet or been smoking in the property, because that might just add weight to the checkout report. But as Mitch said, you know, they can essentially, you know, live perhaps to a lesser standard than you would hope. But as long as at the end of the tenancy they fulfill those obligations, then that's fine, and there's no need to deduct from the deposit.
Does whatever is written in a tenancy agreement override any dispute scenarios, i.e. professional clean the property regardless to how it was at the start?
You wish. I think is probably the answer to that. No, it doesn't. A tenancy agreement, you know, the law intervenes with tenancy agreements. You know, it's essentially a consumer contract. We've got an imbalance of bargaining power between the landlord and the tenant. So there is legislation that governs the tenancy agreement, and we've got the Consumer Rights Act. We've also got the Tenant Fees Act. And one of the things the Tenant Fees Act says is that you can't require the tenant to pay for third-party contractors. So if you've got a clause in your tenancy agreement that says, regardless, you must have that property professionally cleaned at the end of the tenancy, that's not going to be enough. The adjudicator will discount that clause because it is unenforceable. It's got no teeth. And we will make a comparison between the check-in and the check-out report. It is the same as if you put in your tenancy agreement to the tenant, you can keep a dog, but you must have the carpets professionally cleaned at the end of the tenancy and have the property treated for fleas. It's the same principle. You cannot enforce that clause. You must be able to establish on the evidence that your property was less clean than it was at the start of the tenancy, or that there was in fact an infestation of fleas in order to recover those costs.
Can a landlord claim for their own time dealing with the property at the end of the tenancy? So I suppose it's a case of, could an example being a landlord's had to take a day off work to paint the property for whatever reason or repair any jobs?
Well, yes, absolutely. I mean, if the landlord wants to do some of the work for themselves, or if they want to roll their sleeves up and do some cleaning or get the paintbrushes out, then that's absolutely fine. They can recover a reasonable cost for doing that work. It's important to remember, though, it's not going to be the same as a professional contractor would charge. So you can't provide a quote for professional cleaning and think that you can get the same amount because you've done it yourself. That wouldn't be reasonable. The cleaning contractor will have other overheads that the landlord will not be subject to, and the landlord can't benefit from the tenant's deposit. So we won't make that same award, but the best thing to think about really is to apportion a reasonable hourly rate of £15, £20 an hour, and then, you know, however many hours you've spent, that would formulate your claim. If you had to take a day off work unpaid and you work as a brain surgeon, and that's several £1,000s, you know, you're not going to be able to recover those costs from the tenant's deposit. It's only what's reasonable. You'd be better off getting a professional contractor to do it if those are actually going to be your losses.
If I only have photographs, can I still claim from a deposit? How useful are photographs? So I suppose we've had this quite a lot where some people don't actually do an inventory report. They'll literally take photographs and send it to the tenant and say, hey, your photographs, this is what it looked like, but there's no written description. So I suppose it's a case of in this scenario, Martin, is if you only have photographs, can you still claim from a deposit?
Yeah, well, I mean, it's a question that I can't really answer because it depends on what the photographs show. It may well be that you have got the perfect image of that particular item at the start of the tenancy by pure chance that shows it was in good, clean condition. And then at the end, you've got the corresponding photo which shows the opposite, it's in poor condition and dirty or whatever. Then yes, of course, you can make that claim. But as we've already said, it's impossible to take photographs of every area of the property to the sufficient detail that you are going to be able to rely on it to establish your condition and cleanliness at the start of the tenancy. So you can still make claims with photographs alone because, as I've said, it's just evidence of condition and cleanliness we're looking for. But how successful that will be will depend very much on how fortunate you were in what you captured in your check-in photographs, because nobody has a crystal ball. We don't know what's going to fall into dispute.
Thanks, Martin. How does an inventory work in a HMO? It is difficult to take pictures of a communal area as these areas might not be cleaned at the time of the move-in for a new tenant. An inventory and photos can be captured for the individual's room to show the cleanliness, etc. But how does it work for shared communal areas? So I suppose it's a case of HMO, say 6 bedrooms, tenant 1 is moved in January, tenant 2 in February, March, etc. So how would, what advice would you give to someone doing an inspection of the property, given on what that date that tenant moved in for communal areas?
Yeah, well, I mean, unfortunately, I think this is one of those imperfect situations because if you are renting out rooms in an HMO, then the tenancy agreement relates to that room with use of the communal areas. But because other tenants have use of those communal areas, if at the end of the tenancy there is an issue in a common part, how do we know this tenant has breached the terms of their agreement rather than one of the other tenants? So it's going to be very difficult to establish on the evidence that this tenant should pay for those repairs or for that cleaning. So this is something that you need to think about in your management of an HMO. You know, maybe you get a cleaner in, or maybe, you know, I don't know, you conduct more regular visits to try and nip these things in the bud rather than allowing them to mount up. But really, as an adjudicator, it's probably going to come down to what that room that they had sole access to was like compared to the start and end of the tenancy. That's the harsh reality of it. It's going to be very difficult to establish that this tenant has breached the terms in relation to common parts.
We've got about 5 minutes left of today's webinar, so thanks to everyone who's put in all the questions so far. Really, really good. We'll try and box off as many as we can in the last 5 minutes. How do we prove that there was an odour or bad smell in the property? Obviously, difficult to smell a piece of paper, Martin, isn't it? So, of an inventory.
It is, yeah. And I think I see a lot of the Inventory Hive ones. One of the things that it does ask is about neutral odor and things like this. It's important to record it in your check-in and check-out report, because again, you don't perhaps think about this at the start of the tenancy because there's no odor, so you don't think to record anything, but you should be recording it in the check-in and the check-out report. This is why having software available can really pay dividends, because it's giving you that structure so that nothing is missed. Smells do often crop up. Carpets need to be cleaned, curtains need to be cleaned to try and eliminate that smell. So do try and capture that at the start and the end of the tenancy.
What happens if you can't get a quote in time for an adjudication? So I suppose in this case there was damage to a property, but they can't get a quote in time for someone to come and rectify that in time for an adjudication. Is there a set time frame, Martin, of when evidence should be submitted or quotes?
Well, yeah, obviously it depends on what scheme you're using, at TDS, for example, because the timescales are slightly different. If on the insured scheme, for example, then a dispute must be raised within 3 months. And if the tenant raises the dispute, then you have got a very strict time period to respond to that. So it is entirely realistic that you might not be able to get a quote in time for the adjudication. Remember that quote really only goes to the reasonableness of your losses. You've still got to establish there was a breach, which you should be able to do quite easily using your tenancy agreement and your comprehensive check-in and check-out reports. The quote will be about how much you're going to be entitled to recover. So if you haven't got it, we can still consider the claim, and the adjudicator can rely on their own knowledge and experience to make what they consider to be a reasonable award. So it's not the end of the world, but it is always better, particularly if there is something unique about it or if it's particularly expensive for some particular reason, to have that supporting quote or invoice to go with your claim.
Had another question submitted into us. So I have a tenant who moved in 3 years ago. The whole house was newly decorated and freshly painted when she moved in. She would like to renew for another 2 years. The house looks worn down and dirty. I've encouraged her to clean and paint everywhere and showed her the original inventory. She has promised to do this, but I'm reluctant to renew until she does, as if she's stayed there with me for 5 years. Will the TDS allow me to deduct this money when she leaves, or will this be considered wear and tear?
So at the end of what will be then a 5-year tenancy, would we allow you to deduct for redecoration and things like that? Well, it depends on what the evidence shows, but as I've already said, decor, for example, is 3 to 5 years. So if it's just that the walls are marked and rubbed and scuffed, then you're probably not going to get any award after 5 years. We're probably going to say, well, this is landlord's cyclical maintenance. They're going to have to redecorate that property at least every 5 years. So no award for redecoration. But if there is damage, then we can award for that. If there are cleaning issues, if they haven't returned the property as clean as it was at the start, then we can award for that as well.
Just to avoid a bit of time, so I'm just trying to get through as many as we can. So do 360 images add value to an inventory report? So I suppose with Inventory Hive, you can embed 360 images in your report. So from your perspective, Martin, how would you accept these or view these during an adjudication?
Yeah, well, as I've already said, adjudicators want as much evidence as possible, and often, particularly at check-in, you don't necessarily take lots of detailed images of all the nooks and crannies in the property. Having a 360-degree photo can be really useful to the adjudicator to move around the room and find that same camera angle or the same item that's in dispute now and make a direct comparison between condition at the start and end of the tenancy. So they do have use, and adjudicators obviously want as much evidence as they can, and this is pretty much how we view them. We can open them in the same way on the report and zoom in and zoom out just as you are doing there, Mitch.
I suppose it's a good opportunity to see all the light fittings are working. There's a smoke alarm there, for example. The context of the room, the fixtures and fittings, etc. So I suppose you can see from one image everything you need, but I'd still strongly recommend, if there is any damages and defects to a wall, for example, obviously the 360 image might not be able to capture the detail of that. That's where you can then zoom in and capture a better photograph, either using your camera or digital or phone camera through the app, and capture a detailed image of that damages and defect to embed in your report, just like the example I'm about to show you now. So you've got your 360 images, which I've just shown you, plus close-up images if there are any as well. Last couple. Let's see. Can a landlord claim for cleaning and damage if the cleaning does not work?
The short answer is yes. You know, if the landlord is being reasonable and trying to clean a carpet stain, for example, initially, but that cleaning doesn't work, then it would seem wrong to penalise the landlord for trying to be reasonable about their remedies. So it's perfectly acceptable to claim for the cleaning cost and then also compensation for the damage, or perhaps even a contribution towards replacement if the damage is really severe. So yes, absolutely, no problem there.
Last question we've had in is, can a landlord claim when the tenant has put fake grass down and not had permission for lawn?
Oh, well, yeah. I mean, if you've got a nice lawn in the back garden and the tenant comes and puts that artificial grass over the top and kills it all, then absolutely, they're in breach. They've made an alteration to the property without permission. So the cost of removing the artificial grass, I would imagine, the cost of re-establishing the lawn, turf even, you know, it's reasonable to lay turf if you need to get that property re-let, because why should the next tenant have to wait 3 to 6 months for the grass to grow, you know, whatever, depending on the time of year. So it could be a significant cost there to the tenant and absolutely recoverable from their deposit.
No, appreciate everyone's time today. We're slightly overrun today. We didn't get through all of the questions, unfortunately, but we do appreciate everyone's time today. If you do have any more questions about today's webinar, firstly, what I would recommend is take a look at the TDS Academy courses. So TDS alongside Inventory Hive provides some adjudication workshop, some pre-tenancy activity, inventory and checking course, and a midterm and checkout course as well. So I think there's 4 courses in total. Once you complete those, you'll receive your TDS Academy approved accreditation logo, which you can embed on your inventory reports, like for example here, like this on here for you. But I know Martin runs the foundation course and the adjudication workshop. So these 2 are live sessions, and the pre-tenancy and the midterm checkout ones are on-demand sessions, so you can watch those at any time. So did you want to add anything about these, Martin? Because I know you run these courses and how beneficial they are. And I suppose if someone's done their TDS Academy approved accreditation, do you take that into consideration as well when you receive a report?
Well, I mean, I don't suppose it really makes too much difference on how the adjudication is handled, but I would like to think that having undertaken the academy, you will be able to better present your claim and more reasonably claim your costs. I don't run these, but I do present on both courses. I tend to do the foundation course more nowadays, but on Thursday and Friday this week, some of my colleagues are dealing with the adjudication workshop, and it's a really good interactive course as well. You get to answer questions on how you might go as an adjudicator. Definitely worthwhile. Talks more about the sorts of things we've touched on today in great detail, about managing expectations and about betterment, fair wear and tear, all of those principles that adjudicators apply when considering the evidence.
And one last question. How easy is it to record a deposit with the TDS? So how would they go about that, Martin?
Well, I mean, I don't tend to deal with this, but TDS try and make this as easy as possible. So you can call our customer contact center and they can help you. Absolutely. We answer the phone very quickly and everything is geared to make this as pain-free as possible. I mean, one of the big things we try and do as well by doing these webinars and all the information that we put on our help center is to try and drive down the cost of deposit protection as well. So we try and empower our members as much as possible to resolve these disputes without the need to come to adjudication.
Yeah, if anyone wants to learn more about Inventory Hive, if you head over to www inventoryhive.co.uk, where you can create unlimited property inspection reports via desktop or app. You're allowed unlimited users on your account. We're used by landlords with one property, to independent inventory clerks, to independent estate agent branches, all the way up to multi-branch franchise groups and letting agents all around the country. So we are a property mart industry supplier. We're multi-award winning as well, so we've been voted the best estate agent supplier at the EA Masters in 2022 and 2023. But the key thing is our relationship with the TDS and how they like how our reports look. I'm sure Martin loves it when an inventory report comes through to his desk. I'm sure he loves that because they're really easy to read. But we promote tenant engagement as well, to engage with your tenants at check-in, designed to reduce disputes. So yes, that's enough from me. Any further questions, drop me an email at mitch@inventoryhive.co.uk. Any questions that we missed off, I can forward these on to Martin if needed, and he can help answer those on your behalf. So yeah, thanks for everyone's time today. Get in touch if you want to learn more about the TDS or Inventory Hive. Call the number below or head to our website. And thanks for everyone's time, and we'll catch you soon. And thanks to Martin as well.
You're welcome. Thanks very much, everyone. Some great questions.
Thanks, guys. Thank you. Bye now.
Bye.